Some people just rub me the wrong way, and Hank Brennan is one of them. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So I tuned in to watch the hearing that was being held in the issue of whether or not certain people should be allowed to testify. I guess Brennan has made a motion to exclude the ARCA folks who are the accident reconstruction people. I mean, why would you need that information, right? Doesn't make any sense when it's easier to just throw uh, people who have no experience in accident reconstruction up and let them do it. But at any rate, he's trying to suggest that there was some game playing with the discovery when in fact, I think if it was properly characterized, it was his vague discovery requests that caused the issue. And a lot of times defense attorneys will do that. And so he has got a background as a defense attorney. So you write these vague requests, and then when they don't give you what you really wanted because it wasn't spelled out, you claim that they're hiding the ball, playing bad, it's bad faith, they ought to be, tarred and feathered and all that stuff. Well, I don't know whether that's the situation or not, but I can tell you that this man has the most abrasive personality when he is examining a witness, and that may very well play quite well in Boston. But this guy would last about 2 minutes in a Kansas City courtroom because any one of the Kansas City judges would rebuke him for the way he was treating this witness today. As example one, let's take a look at this.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
Not talking
So over 3.5 minutes, he asks the same question over and over and over again, and he keeps asking it in a way that he knows this guy can't answer, because at his level, he's not talking about getting hired. He's providing information about what their standard block of fees are. He doesn't care whether he gets hired or not. The expert witness, use my services or not, it's up to you. They're not negotiating on a fee here. And that's essentially what he's trying to suggest or imply here. And the guy answers his question as best that he can. He's supposed to tell the truth, the whole truth, and nothing but the truth. But Brennan doesn't want to hear the truth. What he wants to have is a narrative that says this guy's a bad guy. And you can see him up there trying very, very hard to give the answer that makes the most sense and is the truth. But Brennan just doesn't like it. So he keeps pounding the table. And every time the defense objects, with one exception, during this little hearing that I heard, the part that I heard, with one exception, the judge allows him to continue browbeating this witness. And what you just saw there was essentially browbeating a witness. You should never do that. Now, of course, he's not in front of a jury, so there's no penalty to him for doing it. And this judge is not going to rein him in, because I'm I'm not sure why she's not reining him in. I'll put it that way. It tends tends to give the appearance, perhaps, of some form of bias. But I don't know whether she's biased or not. I'm just saying it certainly looks like there's some bias there, and she ought to be aware of that, and she ought to be, checking herself. So then we move on to another subject, and he gets just plain nasty.
the end of April, how was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay.
Now, there was absolutely no reason for him to be that nasty to this doctor. The only reason to be that nasty is to intimidate him, to essentially get under his skin, make him angry, make him come back with a snarky report. And this witness is simply too well schooled to do that. And he's holding up very well to the cross examination. He is repeating the same answer and he's saying, "Look, this is what I recall." There is a part of this which I'm not going to play because it's too painful to listen to Brennan's screechy little voice when he does this, but there's a part of this where he asks about text messages that he may have deleted. If I didn't delete text messages every month, I would have 1,000 to 2,000 on my phone at any one time. And do I remember all the text messages that I've deleted? No, I don't have any idea. I try to keep stuff that's family that might be important. I try to keep it for a while, but even that has to go away at some point. The idea that he would, selectively delete emails that are going to hurt the case, that's nonsense because this guy is not an advocate. He is a scientist and he's doing what scientists do. I think Brennan is trying to win points with the judge with this exam, and maybe he is, but if he continues this behavior in front of the jury, he's going to really tick people off. And here's the reality of being on a jury that's not sequestered. The reality is that you have friends, you have spouses, you have children, you have coworkers. You don't have to go out of your way to hear the behind the scenes stuff. You just get it by virtue of being in the same room when somebody else discusses it. And then they go, "Oh, I'm sorry, I shouldn't have said that." But the jurors hear that. And of course, none of them, after they've invested their time in this case, want to be thrown off the jury, so they don't say anything. But they know it. And as a result of that, I think sometimes the word gets back to them in ways that the court doesn't have a way to preclude. And that makes their job that much more difficult. I'm concerned at this point about the way this hearing is being conducted. I'm concerned because the judge seems to allow a lot more leeway to Mr. Brennan than she does to the defense. And I thought what was really interesting about this particular hearing, after he bludgeoned him about, you didn't send all the records, you didn't mention these signal phone calls. Well, he mentioned the phone calls, but what's really interesting is he kept talking about you didn't send this, you didn't do that. All of what he did was completely undone in about 2 minutes by this exchange.
Your Honor, may I approach the witness with the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing record.
Sure, we can mark it.
Yeah, that's exactly, thank you. Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCA had in our possession, we produced.
Now, if the judge was paying attention, he just basically said, "I completely complied with this order." And nothing in Brennan's examination revealed anything to the contrary. You don't have records for Signal calls because Signal automatically deletes at the end of the call. A lot of times you don't have records for Zoom calls because unless you specifically request to record it, there's no record kept of the Zoom call. All the things that he was beating this witness up about, and especially his snarky comments, don't account for a hill of beans in terms of establishing bad faith discovery violations. And the judge should recognize that. I just hope that she's playing it down the middle at this point and is not particularly predisposed to give the prosecution an edge on this issue. We can only hope. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.